All right, so once confirmed, I think the next question is how long do they serve? How long does a federal judge serve? And it's worth pointing out this is not just the Supreme Court we're talking about now. Remember, there are 3 different levels to our court system, and all of them serve the same length of a term. And that is for life. They serve for life. That's a big deal. So there are 3 scenarios in which they could cease being justices. And again, not just Supreme Court, but also the 2 lower levels of the court system. So the first scenario in which they could stop being a federal judge or justice is they could just quit. They could resign. And this doesn't necessarily mean there's some scandal or they did anything wrong. They resigned could mean that they're just retiring. They're done. Another scenario in which they could no longer be a justice is that they could be removed against their will because of some sort of misconduct. And the final one is they could die. So those are the 3 scenarios. Other than that, they get to serve for life. And as I pointed out, a number of justices have served close to 30 years recently. Now, I think one question to ask is why? Why is it that they get to keep serving? There's no re-election, there's no reconfirmation, nothing. And the other 2 branches don't experience that. The president serves 4-year terms and then has to convince people to choose them again. And in the House of Representatives, you have only 2-year term. And then you have to convince the people to re-elect you. And the Senate is 6 years. And then you have to convince the people to re-elect you. With a federal judge, you get it for life. And why is that? Well, they looked at the alternatives. And they said, we don't really like a judge having to be elected. So in order to keep the separation of powers, that's what this says, separation of powers, they decided, you know what, we want these justices to rule based on the law and not worry about what people are going to think. So it says here, the Founding Fathers wanted justices to rule strictly based on the Constitution, what was right. Don't worry about pleasing people. Don't worry about trying to get reelected or reconfirmed. And you don't need to if you are serving for life. And you might ask, well, what if they become bad? Well, we have a process of getting rid of them if they become bad. But that really hasn't been an issue. There aren't justices that radically changed and became crazy. Their job is pretty straightforward. It's hard and complex and takes lots of training to do it well, but it's pretty straightforward, or at least it should be. Does the Constitution allow this? Well, what does the Constitution say? And then just making your decision. And remember, as I pointed out, not all decisions are very popular. Or if you are a textualist or an originalist, they're not going to be maybe most people's common sense, because again, not all laws produce good results. Some laws need to be changed and tweaked. So that's the process of becoming a justice. So now let's look through and see how they get along with the other branches. Before I get to that though, because they serve for life, the length of their term is kind of forever, or the whole length of their life, many people consider this to be a president's greatest power and their most important legacy. And I remember when Donald Trump was running against Hillary Clinton, that for many people this was the big thing. Don't elect Donald Trump, because look at the crazy people that he's proposing to add to the Supreme Court. And on the other side, some people said, don't go with Hillary Clinton. Are you crazy? Look at the people she would pick for the Supreme Court. And that was a really major influence for a number of people. And it looks like it might be again here. People could say, look, you may not like Trump, but he picked some good justices, if you agree with them. So despite all the crazy things he may say, you gotta re-elect him, because we have, again, as I pointed out, let me go back. As I pointed out, these three justices, Clarence Thomas, Ruth Bader Ginsburg, and Stephen Breyer, could be retiring, like they could resign, or they might die. And so the next president could potentially pick 3 more justices. And that's a lot of power because they serve for life. And if they choose young people, like Barack Obama and Donald Trump have done, and George W. Bush for that matter, Roberts, Alito, Kagan, Gorsuch, and Kavanaugh are quite young. And Sotomayor is certainly much younger than Thomas Ginsburg and Breyer. So that's a big deal. And you might also say, you know what, you might not like Joe Biden or Bernie Sanders, but, and this is something that others could say in this upcoming election, you might not like them, but do you want Donald Trump picking the next 3 Supreme Court justices? So this is a very important power that the president has, a lot of sway and influence over the Supreme Court in that regard. And some people will choose not to retire. I'm sure Ruth Bader Ginsburg, if she has it in her, she's not going to allow herself to retire or die if Donald Trump gets reelected, or at least she did that for this term. Yeah. Anyways, John Adams, he once said, "My gift of John Marshall," remember he's that very influential Supreme Court Chief Justice, not the first, but the first, like, really important, influential one. He said, "My gift of John Marshall to, I believe it's the American people, to the people of the United States was the proudest act of my life." And some people say it's kind of the greatest achievement of his presidency. And yeah, I mean, again, I'm going to go back to the slide. I keep going back here, but look at this. George W. Herbert Walker Bush, he passed away. He hasn't been president for about 30 years, and he still has someone on the Supreme Court. Bill Clinton hasn't been president for about 20 years, and he still has 2 justices on the Supreme Court. So this is an important part of your legacy. And these decisions that are made by these presidents, the decisions made by their appointees to the Supreme Court, they last ages. People are still talking about Roe versus Wade. That was from 1973, and people talk about decisions made in the 1800s even. So this is a very important power. All right, now, how do they get along? Well, presidents don't always agree with the Supreme Court. You maybe have read some of the articles about the tension between some Supreme Court justices and congressmen and Supreme Court justices and presidents, like President Trump and President Barack Obama. So I should update this. But here are some examples. Abraham Lincoln didn't get along with Chief Justice Roger B. Taney when it came to a number of decisions, such as suspending habeas corpus. Franklin Roosevelt here, FDR, he tried packing the court, meaning he tried adding a bunch of justices so that his New Deal and other policy matters would be approved by the Supreme Court. So FDR was doing a whole lot of stuff to try to fight to the Great Depression, and that's kind of summarized by the New Deal. And not all of it was upheld and viewed as constitutional. And so he was getting frustrated by that, and he threatened to pack the court, meaning he was going to increase the number of justices, and he would be picking them. And then these new Supreme Court justices would approve of his policies. Similarly, Barack Obama, he disagreed with the Supreme Court's ruling on whether or not corporations and unions can give contributions to candidates to their political campaigns. He said that is not, with all due respect to the separation of powers, the Supreme Court made a bad decision, or maybe didn't even quite say bad decision, but that it was a dangerous decision. And a Supreme Court Justice, Samuel Alito, he was caught on camera mouthing, because he said this, Obama said this during the State of the Union address, and Alito was caught on camera mouthing, "not true." And that led to some tension. Then, more recently, Sonia Sotomayor and Ruth Bader Ginsburg, two more left-leaning, more appointed by Democrats, they criticized President Trump, and or I should say they criticized the rulings that had been made in favor of President Trump. And then Trump said that those two justices should recuse themselves. And recuse is kind of admitting, I've got a conflict of interest, I'm biased, so I can't fairly make a ruling. And he said they should recuse themselves from all future cases that involve him because they look they showed their bias, and you're not supposed to be political. So it's not uncommon for there to be clashes between the Supreme Court and the presidents. A common abbreviation used, or initialism, is called SCOTUS. People use SCOTUS. So POTUS for the President of the United States. SCOTUS is for Supreme Court of the United States. One kind of interesting bit of trivia. President William Howard Taft, and I said this in a previous video, is the only person to head or lead two branches of our government. So he was the head of the executive branch as president from 1909 to 1913. And then in 1921 to 1930, he served as Chief Justice of the United States, the head of the Supreme Court. And here he is pictured here as Chief Justice, and here he is pictured as President. One other kind of interesting tidbit of trivia is that we had an NFL football player who went on to become a Supreme Court Justice. So his name was Byron Whizzer White. Whizzer was his nickname. And he led the NFL in rushing yards in 1938 and in 1940. And then he went on to become a Supreme Court Justice. So, yeah, justices come in all shapes and sizes. One thing about packing the courts, this is not just a thing from the 1930s with FDR. Now people who dislike President Trump are saying, okay, if he's going to pick justices, so this is kind of where we're at right now. We have 9 total justices on the Supreme Court. 5 of them have been chosen by Republicans. 4 have been chosen by Democrats. And they said it's not fair. If no other appointments get made by President Trump, then they said the next time a Democrat gets elected, if this is still true, we're going to add 2 justices to the Supreme Court. So then, in that case, the total would become 11 justices on the Supreme Court. There would still be those 5 Republicans, 4 Democrats, and those 2 new ones would be named or appointed by a Democratic president, and so they would fall in the Democratic camp, and then there'd be 6 Democrats and only 5 Republican ones. But the problem I see with this is that it's just going to continue and going to completely undermine the way the Supreme Court operates, because what prevents the next Republican elected president from saying, oh yeah, well, I'm going to add 2 justices then, and I'm going to make sure that they are Republicans. So we have 5 here and 6 Democrats here. Well, those 2 justices are going to be appointed by a Republican, and then we'll have 7 Republican justices and 6 Democratic ones, and then the Democrats will get reelected, and there will be 15 judges. And this is not a good, sustainable model. And I think, again, coming back to it, I think the root problem here, is this. We need to figure this out. How do we view and read the Constitution? It shouldn't be hard. There are very few disagreements when it comes to other matters. You know, it's not a heated debate for the county recorder or for the city clerk. Police, if they pull you over for speeding, it's straightforward. Why? Because it's very clear. It's an originalist or textualist position. This is the posted speed limit. It is 65 miles per hour here. You were going 70. You were going, even if you were going 66, you could be upset and bothered by it and say, "Oh, come on, where's the common sense?" But at least it's very clear. You know whether or not you are following the law or technically breaking the law. And most people, when it comes to something like speeding, say, "Yeah, technically I'm breaking the law, but police follow a certain amount of common sense. So I could technically be pulled over, but it's not very likely." Another example could be curfew. It's technically, the text of the law says, in Fulton, Illinois, if you are under this age and out at this time, you are breaking curfew. Does that mean the police are going to every single time stop you? No. It just means that they can. So there can be areas for kind of common sense and still the originalist or textualist position. But coming back to what I was getting at, if it doesn't matter if a police officer is Democrat or Republican, they're going to pull you over if you speed above a certain amount. It doesn't matter if you're Democrat or Republican. If I ask for a marriage certificate from the county, or if I'm going to pay my property taxes, it doesn't matter if the person collecting them or the assessor is a Democrat or a Republican. Why? Because it is very, very strict and clear. Using the text of the law, this is what you can do, this is what you can't do. This is the process. And that's why I personally prefer the originalist or textualist position. And if there are some of those things that aren't covered, okay, then add it. Like, if you look through history, slavery was allowed. That was the original intention of the Constitution. That's what the text said very clearly. People didn't like it. They didn't just say, well, the Constitution's a living document and we don't like slavery anymore. They passed the 13th Amendment, which said you can't have slavery anymore. Blacks couldn't vote. Well, the laws on the book said you could discriminate based on that the blacks didn't inherently have that right. It used to be that white people didn't. You had to own land in order to vote. And then they changed the laws and said, we are going to change this. You don't need to own land. That didn't require a constitutional amendment because states can change that on their own. Just like states could allow blacks to vote, and some did. Just like some states allowed women to vote before the 19th Amendment was passed. States have a lot of flexibility, and that's kind of the basic argument of many conservatives today. If you don't like something, then change the law at the state level. If people wanted a right to an abortion, try to change your state laws. I mean, you can try changing the Constitution to include that, but people complain, well, that's really hard. And it's like, yeah, it's supposed to be hard. We don't want the law changing, again, all the time, willy-nilly. It's intentionally made to be a hard process. So I think the drama going on at the Supreme Court over this type of thing would vanish if we could just settle on a textualist or originalist interpretation of the Constitution. And the only reason it's an issue is because people want a living Constitution. And you don't know what you're going to get then. I think I'll pause there.